Evaluation. In evaluating the evidence, it is incumbent on me to assess the evidence of the state and the accused to determine whether the state had proved its case beyond reasonable doubt. In doing so, I must keep in mind that the evidence of a single witness must be approached with caution. Furthermore, it would be wrong to say that I believe the complainants and therefore the accused defense must be rejected as false. Where there are two mutually destructive versions before the court, the matter must be approached as was set out in National Employers General Insurance Company Limited vs. Jagers, 1984-4 SA 437E, where the court remarked as follows. It seems to me with respect that in any civil case, as in any criminal case, the onus can ordinarily only be discharged by adducing credible evidence to support the case of the party on whom the onus rests. In a civil case, the onus is obviously not as heavy as in a criminal case, but nevertheless, where the onus rests on the plaintiff, where there are two mutually destructive stories, he can only succeed if he satisfies the court on a preponderance of probabilities that his version is true and accurate and therefore acceptable, and that the other version advanced by the defendant is therefore false or mistaken and falls to be rejected. In deciding whether that evidence is true or not, the court will weigh up and test the plaintiff's allegations against the general probabilities. The estimate of the credibility of a witness will therefore be inextricably bound up with consideration of the probabilities of the case, and if the balance of probabilities favor the plaintiff, then the court will accept his version as being probably true. If, however, the probabilities are even balanced in the sense that they do not favor the plaintiff's case any more than they do the defendant's, the plaintiff can only succeed if the court nevertheless believes him and is satisfied that his evidence is true and that the defendant's version is false. There are certain problems with the evidence of the complainants. No corroborating evidence was presented for the complainant's evidence. There must have been witnesses with regard to the first reports they made, which the state did not call. First reports do not prove that a victim was raped or sexually assaulted, but it does prove consistency and that it was not a recent fabrication. There would have been telephone records that could have corroborated the witnesses' evidence that they had to call or text accused daily or regularly. No such evidence was presented. If the evidence of the complainants is analyzed, it cannot be ignored that there is proof that some of them deviated from their police statements. The possibility cannot be ignored that Mr. Ntelwa had a much bigger influence on the witness's testimony, but the opportunity to test that had passed, as his attempted influence only came to the fore after they had testified, so there was no opportunity to cross-examine them on the possibility of the interference. Ms. Gianni, whose testimony was found not to be credible, was the person who indicated that she had laid a charge and that the police will contact the witnesses. It seems it was after this that the investigation into the conduct of the accused commenced. What casts a shadow over the evidence of the twins is that even after the arrest of accused one, the twins still publicly professed his innocence and danced in front of television cameras to show their support for him. They were not minors at the time. Sarah Mofokeng was 19 years old when she testified that she lied to accused that she was menstruating and was sent home. However, she returned to the mission house despite knowing what would be expected of her. Mr. Doberman is correct in his argument that it cannot be established what the influence of Mr. Ntelwa was on the evidence of the witnesses, as the suggestion by Mr. Ntelwa was not known at the time they testified. Mr. Caesar, on behalf of the state, argued that I should accept the similar fact evidence of the state witnesses. In State v. Nduna, 2010, ZASCA 120, the following was said in paragraph 17. It is settled law that while similar fact evidence is admissible to prove the identity of an accused person, as the perpetrator of an offence, it cannot be used to prove the commission of the crime itself. This legal principle operates in addition to exclude such similar fact evidence from being confirmatory material on another count. However, the application of the rule is not to be confused with a situation where the rule is invoked to establish the cogency of the evidence of a systematic course of wrongful conduct in order to render it more probable that the offender committed each of the offences charged in respect of such conduct. The appellant's argument, if it were to be accepted, would be tantamount to excluding evidence of the modus operandi of the appellant merely because he had been charged with more than one count of robbery. End of the quote. Witnesses in the instant matter were in contact with each other and discussed the case before charges were laid, but it was not disclosed to what extent. There is an additional problem that there had been a WhatsApp group where all the complainants were part of. Mazondi took the lead in complaining about the appointment of Advocate Serfontein as the prosecutor in the matter, proposing that Mr. Ntelwa remains. Furthermore, Mr. Ntelwa was the prosecutor who indicated that witnesses should be influenced to stick to their police statement. The case can be distinguished from the Nduna matter, where there were two robberies months apart with a similar modus operandi. The similar fact evidence cannot be taken into account in the instant matter in the light of the fair trial principle. The primary factor, unfortunately, is the lack of cross-examination of the accused. As indicated earlier, if there's no cross-examination on issues in dispute, it would be unfair to reject an accused's evidence if he or she has not had the opportunity to explain such issue. As the cross-examination of the accused was of such poor quality, it had the effect that the accused's evidence was not placed in dispute at all, and therefore it did not necessitate the calling of corroborative witnesses, if any, who might have bolstered their defense. A further factor that I have to take into account is the conduct of Mr. Ntelwa and the irregularities that his conduct precipitated. If he had been removed at the time the prosecuting authority intended to remove him, the outcome might have been different. Furthermore, I'm of the view that it is highly undesirable that the complainant can dictate who should prosecute in a trial, especially where a decision has been made to remove a prosecutor. I'm of the view that although there are aspects of the complainant's evidence that are unsatisfactory, I cannot find that their evidence is incredible. However, I cannot find that the evidence of the accused falls to be rejected as false either. This is especially so as the accused's evidence was not placed in dispute through proper cross-examination. When deciding whether the state has proved its case beyond reasonable doubt, this matter falls into the category where, in my view, the explanations of the accused are improbable, and I don't subjectively believe them. However, due to the uncertainty of the actions of the state and the lack of proper cross-examination, I cannot find that the accused's version are so improbable that they cannot reasonably possibly be true. The accused bore no onus to convince the court of their innocence. I am of the view, in the light of all the circumstances of the case, that the state has not proved its case beyond reasonable doubt.
Yes. Quiet, please.
The accused are found not guilty and are discharged on all the charges. The court will adjourn.
All right.
All right, so there you have it. Some breaking news at this hour. Timothy Omotoso and his two co-accused found not guilty of rape, human trafficking and other abuses in their 8-year-long trial. We're going to stay with these live visuals as long as we can. You can see the controversial televangelist and two other women in the dock seemingly praying inside the courtroom. It was quite a lengthy judgment delivered by Judge Irma Schoeman just a short while ago, and it really came down to the nature of the cross-examination inside this particular case. In fact, Judge Schoeman saying that she found that the evidence brought by the accused may very well not have been true. However, she says she doesn't rule out the possibility that it could have been true. Let's continue listening in and get a sense of what Timothy Omotoso has to say.
I am 67 by July, next July. I've been in prison for 8 years.
Are you looking to maybe, take action forward, seeing as you're not guilty and you've spent so many years?
I think it's better for me to rest first. I've been in prison for 8 years at this age, so I think we should give some time for that.
Pastor Sally, what's the first thing you want to do when you get out of prison after 8 years?
Only God can tell me. When it is time, God will speak to me.
And then anything else you would like to add?
Anything to add, please?
You say you have one.
Anything to add?
Anything else you want to add?
All right, once again, live visuals there of what's taking place inside the High Court in Gqeberha. I wonder if we can stay with those visuals, guys, to try and get a sense of the reaction, at least inside court, in the wake of this breaking news. Timothy Omotoso and his two co-accused found not guilty after being, of course, on the dock or on trial for about 8 years. I was still explaining that Judge Irma Schoeman has mentioned that even though she had found that the evidence presented by the three who were accused in this matter was improbable, she said there was a scenario where it could have been true. Let's listen to Lerato Fekisi inside court.
Declared unguilty on all charges. The state's just really failing in terms of making sure they do a proper cross-examination. Judge Irma Schoeman speaking about the poor cross-examination and saying that they did not present evidence that warranted for them to be arrested, and saying that the cross-examination was indeed a failure. The cross-examination was indeed bad, and reason for that now they've been made not guilty on this case.
Once again, that's our reporter Lerato Fekisi inside court. As you can see, we're beaming live visuals for you of the reaction immediately as it takes place outside court. A heavy police contingent that's present there to capture seemingly the supporters of the televangelist who have followed this case for the 8 years that it's been on the court roll. Many of them unwavering in their support for Timothy Omotoso, maintaining his innocence. And in fact, once again, the judgment that's been given doesn't seem to have relied much on the evidence. Judge Irma Schoeman ultimately putting her outcome on the nature of the cross-examination, saying that the onus was not on the three who were accused in this case to prove beyond reasonable doubt that they're innocent. The onus, in fact, was on the state itself to continue with their cross-examination and essentially to bring forward a case that can be proven beyond reasonable doubt. It's an outcome that I imagine is going to have far-reaching implications given the many issues that have come under a spotlight since this matter came to the fore, including, by the way, the nature of the cross-examination of witnesses who, of course, are said to have been on the receiving end of sexual assault. Judge Irma Schoeman spent a considerable amount of time in her judgment, almost lasting an hour, by the way, going really painstakingly through the evidence that was brought forward by the witnesses, rehashing some of the salient points of their testimony, where in many instances, one witness after another, they were called inside a room, we're told, with Timothy Omotoso, and it claimed in front of the court that, in fact, he had made similar, or a number of requests, I should say, requests which without a doubt would have raised eyebrows. Things like asking some of the women who had taken to the stand to join him on his bed, for example, and other requests which I probably shouldn't repeat around his interaction with their bodies, for lack of a better term. Lerato Fekisi, I'm told, is able to hear us.